Welcome back to Black Belt Secrets. It's been a while, I know, but Harry's back in the news again, and the headlines would have you believe that he's got some sort of slam dunk win in the Court of Appeal. But that's not really the case. In fact, it's very narrow. I've done a longer, more in-depth video over on Black Belt Barrister, which you'll see go out today as well. But I just wanted to comment on it here because you can see from these headlines that it reads that he's won the right to challenge the UK police protection ruling in the UK. Now, that is technically true, but I wanted to give you a bit of a frank view on this judgment. Now, it is just my view here, but you see in this judiciary publication where it's released just the order from the Court of Appeal. What it doesn't include is the application itself and all of the grounds, which I think are different to the original grounds. Some of them might be broadly similar, but this appears to be a specific application to the Court of Appeal for a second bite of the cherry, as it were, to seek permission to appeal, which he's got on a very narrow basis in my personal interpretation, because I've seen enough judge rulings now to know that when a judge writes something in this sort of way, it just seems to me that the judge was reluctant in granting this permission. It's not to say it wasn't valid, and that the ground obviously is a valid ground to have this heard at an appeal level. Otherwise, the judge wouldn't have granted permission. But just the wording of it here, it says, on consideration of the appellant's notice and accompanying documents, but without an oral hearing in respect of an application for permission to appeal. Although the carefully reasoned judgment of Sir Peter Lane may prove to be correct in all respects, I am persuaded, not without hesitation, that an appeal on ground one would have a real prospect of success. So, judge not particularly quick to grant appeal here. The judge has reservations, and simply looking at this from a completely neutral perspective to say ground one, which is not entirely clear what it is, has a real prospect of success. Now, what is a real prospect? It just means that it's an argument that could win. It's not entirely baseless. It's not entirely unmeritorious, unarguable. It is an argument that they can run, that they can support, and it may well succeed. And that is the narrow point on which this judge has granted permission. Whereas when you see all the headlines, you might see it as, he's had this huge win and may not fully understand it. So whilst it's technically a win for him because he's won permission to appeal, it's not really encapsulated in the headlines fully as when you read this judgment. So I'll link it below and you can go and read it for yourself. And now, bearing in mind that this is all arguing over the security when he visits the UK, the potential impact of a successful attack upon him and so on, but it is essentially the difference between the default protection, which I understand to be armed police round-the-clock protection, as against a bespoke package of security that they put in place depending on where he is, what he's doing, how long he's going there for, and so on, all of which I've discussed in previous videos. So I wanted to do this brief video here just to outline what I really think. I think it is a very narrow technical permission to appeal, and ultimately, I don't think the appeal will be successful, but we will wait and see. But I will just state that as a prediction here early on, and we will wait and see what happens, because, of course, nothing I say here is going to affect the court in any way whatsoever. So I'll be very interested to see what happens in this. But interestingly, also, his lawyers asked for this case to be expedited, heard much more quickly. Not interestingly, on the basis that it's Prince Harry, therefore it must be heard more quickly. Instead, they must have relied on, the two reasons relied on. Firstly, that it was approaching 3 years from issue, which is correct. And secondly, that they're engaged in a long matter from October 24. And so it's a bit of a strange way of saying, well, this has been a long time and we will be busy from this year onwards, so we'd like to get this heard beforehand. But the judge has said, no, you can wait in line like everybody else and it will get heard when it gets heard. So that is it, really. It's a very narrow ground. It's a very narrow permission from what I can see, although I haven't seen the full application, of course. But let me know your thoughts in comments. Check out my longer, more in-depth video on exactly this over on Black Belt Barrister if you're not familiar. I'll link it below. I hope you enjoy that. Thanks for watching. Make sure you subscribe here. I will be back here with many more videos of my personal views on these kind of things. They are just my personal views, but that's what you're here for on Black Belt Secrets. So thanks for watching, and I'll see you very soon.